Everyone, this is Hassan Chishti, immigration lawyer at Chishti UK Immigration Law and Visa Advisor. Today, I want to share a very important update about dependent eligibility for the UK skilled worker visa, specifically how the transitional protection rules that came in on 22nd of July 2025 have helped real applicants. So let's start with the background. On 22nd of July, the UK government made major changes to the skilled worker route. One of the biggest changes was increasing the minimum skill level from RQF Level 3 to RQF Level 6. Because of this, around 180 medium skilled roles were removed from general eligibility under the skilled worker visa. Under these new rules, dependents of skilled workers in medium skilled roles are normally no longer allowed to apply unless they fall under transitional protection. Now, what does transitional protection means? It simply means that if someone applied before 22nd of July 2025 or already held a skilled worker visa before that day, they can continue under the old rules even if their job is at medium skilled. This protection keeps very important rights in place, including the right to bring the dependents, the right to extend the visa, and the right to change employers under the old criteria. So the date of application becomes extremely important. Let me give you a real case example. A client approached us with the concerns about their dependent visa. Their job was at medium skilled, which would normally fall under the new restrictions, but their decision was issued on 6th of July 2025, which is before the rule changes. Because their case fell within the transitional window, they were still allowed to bring their dependents under the old skilled worker rules. The timing saved the entire application and allowed the family to remain together despite the new regulations. And it is very important that you do highlight when you make an application. You may write a separate letter telling the Home Office that because of this transitional arrangement is not applied on you because you got your visa response before that change came in on 22nd of July 2025. Now, there is another important update which is with regards to the English language requirement for the dependents as well, which is coming in on 8th of January 2026. So if you want to make a skilled worker visa dependent application, you should try to make the application before the English language requirement that comes in on 8th of January 2026. So let me summarize the key points now. So if your skilled worker visa or certificate of sponsorship was issued before 22nd of July, you may still bring dependents under the old rules. New applicants after the date must meet RQF Level 6 skill requirements and may not be able to sponsor dependents. From 8th January 2026, new skilled worker application must meet the English language requirement, and transitional cases remain under the old rules for both dependents and English level. This example and this win and success story shows how the timing of an application completely changed the outcome. Thank you for listening, and if you are in the similar situation where the transitional arrangement is having effect on your case, you can reach out to us on our provided contact number and we can help you to make successful application.